Members, we have a quorum, and this is the appointed time. So please do not speak from your seats. This is the Bills Committee on Private Columbaria Bill. This is the 4th meeting. And let's begin, and let's invite the administration in to help us with the discussion. Now, item 1 is meeting with the administration. So, members, in relation to the discussion and points raised last time, the administration has prepared papers in response. On the 25th of November, the Bills Committee raised some issues at that meeting, and the administration has made the response via LC paper number CB bracket 2431/1415 bracket 01. Also, CB bracket 2431 bracket 02 contains the administration's response to the funeral trades submission. Also, CB bracket 2431/bracket 03 is a proposed work plan, which is a response given by the administration. I will go through the responses and allow members to follow up on them. So please refer to CB bracket 2431/1415 bracket 01, which is issues raised by members and responses made by the administration. Attending today's meeting, we have from the administration Ms. Diane Wong, Principal Assistant Secretary for Food and Health, Ms. Phyllis Cole, Senior Assistant Law Draftsman from the Department of Justice, Mr. Yu Tek Chang, Assistant Director of Buildings Department, Ms. Chu Lan Ying, Assistant Director of Food and Environmental Hygiene Department, Ms. Olga Lam, Assistant Director of Lands Department, and also Ms. Christine Lee, Chair, Assistant Director of Planning from the Planning Department. So welcome. PAS, on this paper, would you like to walk us through the paper first? All right, Chairman. Thank you, members, for your views expressed last time on 3 major concerns. This paper sets out our responses. I'll see if members would like to follow up on our response. I think the first issue has to do with the validity period of license. Last time, some members said that the maximum validity period of 10 years may be too short, and members have suggested setting it to be coterminous with the term of land lease, and I'd like to set out the background here. In fact, the bill sets out detailed requirements. In applying for a license, the applicant is required to hold the premises directly from the government, meaning that the applicant should be the landowner or the lessee. Be it a pre-bill columbarium or a post-bill columbarium, we hope that the applicant should run the business on self-owned premises. However, we understand that due to historical reasons, this requirement of self-owned premises may not be met. We therefore also allow that if it is not run on self-owned premises, the applicant should at least have the right to continue to use the premises for at least 5 years before we consider the license application. Secondly, the licensing board may determine the term for which a license is issued, renewed, or extended. And the period must not exceed the shorter of the following. That is either the tenancy or remainder of the tenancy or 10 years. That is to say, if the tenancy is only for 8 years, it's not possible for us to give a 10-year license. So it's shorter of the two. And we also have drawn reference from the Telecommunications Ordinance of similar license applications, and we also have a review mechanism for these license applications. In paragraph 5 of the paper, we have given a very detailed analysis of the figures. In terms of the expiry date of land lease, the expiry date ranges from 2038 to 2886. Now, it's a long period of time, and we need to strike a balance. Apart from facilitating the operator and consumers, we also need to understand that there are grave concerns from residents living nearby the premises, and the licensing department and other government departments will also monitor the licensee to make sure that the licensing conditions are met. So we need to strike a balance, and I hope members would understand it. For example, must the tenancy or must the contract not exceed the licensing period? Now, the bill sets out very clearly that the period must not exceed the land lease, but what about the licensing period? It's for the operator and consumers to pay attention to details of the contract, and that consumers should also pay attention to protecting their own interests. We are going to provide template contracts in the future. If necessary, the consumers should seek their own legal advice. Say, if the owner ceases operation, or if the license is not renewed, what should be the compensation arrangement, and how should the ashes be disposed of? And it is also the responsibility of consumers to protect their own interests. Having heard members' views and having considered our policy objective, and originally we considered other arrangements applicable to other licenses. For example, for FEHD's general licenses, undertakers licenses, the period is 1 year. For telecommun or broadcasting licenses, is 12 years. But having considered the nature of private Columbaria licenses, and in order to strike a balance between residents in the neighborhood and consumers and owners, we believe 10 years to be an appropriate balance. And we understand that if in the license period the licensee meets all the licensing requirements or conditions, then does he have to worry if the license will not be renewed? In normal circumstances, once the conditions are met, normally the license can be renewed. And there was also a suggestion of revoking a license upon midterm review. But this will bring uncertainty for operators and consumers, which is a departure from our original purpose of providing certainty in these arrangements. So we believe 10 years to be an appropriate period. Mr. Wong Kwok Heng, Albert Chan, Gary Chan, we have these members waiting in line. So 7 minutes each. Maybe you can't use up all the whole 7 minutes, but we want to have an efficient discussion. Mr. Wong Kwok Heng. Chairman, I'd like to follow up on the administration's response on the license period. Now, I heard the administration's explanation just now. However, my concern hasn't been addressed. As we all know, family members of the deceased could take part in the drawing of lots for government niches, and if they're lucky, this can be done in one go. And as we understand, as an informal rule, this niche should be permanent. It's not just for a period of 20 or 30 years. However, for the private Columbaria bill, the renewal period is 10 years. And just now you talked about a number of reasons for consideration.
When the consumer buys the niche, now how can it be stipulated in the contract that the niche is for the same period as for the lease? Now, some of the leases in your table run as far as 2886. So the term of the niche should be at least that of the lease, and it shouldn't be just for 10 years, because in 10 years the relatives might not be in Hong Kong, or you don't know where that person might be. So it's important to safeguard the interests of the consumer. Secondly, some people, when they buy the niches, they are charged various fees, management fees, joystick fees, all sorts of names, and very vague. But they have to pay a sum of money, but they don't get enough safeguards. Now, after this bill is passed, in the detailed provisions, now I understand that there will be a blueprint. Can you tell us about the contents? Deputy Secretary? Thank you, Chairman. Now, if you turn to C473 or C73474, it's clear that the niche period cannot go beyond the lease, and then in a schedule, the use of the niche cannot run beyond that period. And then in Schedule 4, if you look at the provisions, we ask that the lease period must be made clear. That is on page C3609, or the Chinese is on 3608. And we also require that the now we are in Schedule 4, C3608. Now the essential terms. Now, if you look at 1BC, the term for which the land on which the columbarium is situated is held from the government under a lease that has to be stipulated, and the interment right being sold, the fee should cover what items. Now in 2B4, that's on page C3610, and when the interment period comes to an end, what will be the provision, and the fees should be clearly listed for the consumer. And then under C, when the lease is renewed, the interment right, how will that be dealt with, and what fees are to be shared? Those have to be stipulated, and we will provide a template of a contract for the public to refer to. Thank you, Chairman. Now, I hope the administration will be clear once again. Now, you say that 10 years is the term, but that doesn't affect the rights of the purchaser. Is that right? Now, the period is for 10 years, but if the purchaser wants to go beyond the 10 years, that can be achieved, but he or she has to read closely the provisions on how his rights are protected. Now, after this bill comes into effect, is it possible that there may be irresponsible vendors who say that they sell the interment right for 10 years only, and then you will have to renew the contract with me after 10 years? Well, that has to be stipulated clearly, and the consumer can choose not to buy from that vendor, or and what are the terms under which they enter into the contract. Mr. Albert Chen. Chairman, I hope that through this bill, through legislation, we can deal with all problems involving the Columbaria. Some of them are very absurd. Now, a problem is that now whether the validity period of the license is for 10 years or 20 years, there's a problem because the niche is forever. Now, in principle, it's 50 years or 100 years, or in fact forever. And that period is in conflict with the lease, and there are conflicts of interest. For instance, I'm the owner of the land. I have sold all the niches, but the land is mine. Then if the license is not issued, or the land cannot continue to be used for columbarium purpose, and I change the land use, then the then the new owner may not be operating efficiently or well, providing a good service. Now, under many contracts, there may not be service fees. So how will you legislate to deal with all of these conflicts of interest? The first conflict of interest, the landowner, between the landowner and there may be conflict of interest arising out of the issue of the license. And secondly, some of the Columbaria have not had gained the formal approval of town planning board or the relevant authority, so to use the land for that purpose. So the land might be for agricultural use, or residential use, industrial use. So the interest involved may be different. So if you issue a 10-year license, now these people, if they are conscientious, they continue to operate, and if can make money, they will continue to operate. Once they've sold all the niches, they don't have the motive to continue to operate. Now, you have to issue a license that's on a permanent basis that coincides with the term of the lease, and it has also to be approved by the town planning board. And the they have to be bundled, and none of it can be varied or changed. So that way, the columbarium stands a better chance of being operated on a permanent basis. You must find a way to deal with these issues in the course of this legislation process. Now, you might introduce some penalties, and in the land grant and in the town planning board approval, you must deal with these matters too when you issue the license. Now, if they change the purpose in the future, then the ashes may have to be moved elsewhere, and who knows where they will end up. Thank you, Chairman. We understand Mr. Chan's concern, but well, I will talk about how to address Mr. Chan's concerns. And please understand that we have made a big step forward, but it is not a panacea to resolve all the problems, historical problems, but at least we have established a framework based on which improvements can be made. Now, on the issue of permanence, well, nothing can be permanent, so there will always be this problem. Please let me finish first. Now, society changes also. Of course, we try to do the best. Now, in the provisions, we ask them to meet every town planning board requirement, but as society changes, the town planning regulations also change. The leases might also be modified. So, and this is not always resolved. But a license system is better than no licensing system, because the consumer gets better safeguards. And when we come to parts 2 and 3, we will talk about the ash. Now, the operator has to properly deal with, provide for the interred ash. We have provisions covering that. If he doesn't comply, there will be severe penalties. Now, he can be penalized summarily for $2 million or imprisoned for 3 years, and that can go up to $5 million and imprisonment for 7 years if it's through trial. Now, now I will explain further what happens when he ceases business. Now, in part 3, it depends on the circumstances of each case. There might be 2 cases. Maybe the operator is at fault, or he hasn't been able to comply with the contract. It's frustrated. It's not because of the fault on either side. Then the consumer can still get compensation, seek compensation, or annul avoid the contract. Chair Ken? I'd like to also follow up on the 10-year validity period of the license and the land lease issue. Now, the PAS said that, of course, we won't give him a 10-year license if the lease has only 7 years left. Now, in the table in Part 5, now paragraph 5, there are some of the leases are run for very long periods. Now, if you issue only a 10-year license, then I'm concerned that some bad operators, they only provide for a certain period and then charge you more afterwards. Now, it can be that the lease is for 2047, and then when I sell the niche, I say I will continue to operate. But when my term is up, I cease my business, and then I deliberately sell to another person. And how will the ash be dealt with?
Well, for the ashes, the operators may know that the government will have some fallback arrangement. So they have charged the consumers for the whole period of the contract, and yet on expiry of the license period, the business would be assigned to another party. And my concern is that if the license period is not coterminous with the land lease, there could be a gray area for unscrupulous business operators. So can you clarify this? Thank you, Chairman. Thank you, members, for your concern over the validity period of the license. At both meetings, we have heard members' concerns and suggestions that the period should be longer. And you may recall that according to the deputations at a public hearing, many residents are affected by the nuisance, and they are very concerned. And it is hoped that operators can comply with the licensing conditions all the time so as to minimize nuisance to residents nearby. Of course, we have heard these suggestions, whether it should be 10 years or longer. Maybe we can rethink. Just now, some members suggested and asked whether some unscrupulous operators would just pocket the money and close down the business. I will explain a bit further. Of course, each case differs in terms of the facts and the legal issues involved, so they should seek their own legal advice. Now, let's say without a reasonable cause, the operators fail to apply for a license or apply for renewal of license on expiry of the license, then consumers could file a claim with the court to pursue damages. And the court can decide whether the fault is on the part of the operator or whether the non-performance of the contract has to do with other circumstances. And consumers can put forward grounds and seek damages. Now, if the non-performance has nothing to do with fault on any party, maybe due to objections from residents and that the operators failed to get a license, and if this is accepted by the court, then consumers can still pursue compensation through frustration of contracts, and consumers are not required to pay the sum payable had the contract not been nullified. And the court may consider that the operator has also spent some money, or quite a lot of money, in going through the town planning procedures, setting up the establishment, so on and so forth, and costs may have incurred. for the non-performance or frustration of contract. The court will also respect the provisions in the contract. Of course, well, Chairman, I'd like to stop here now because I don't have much time left. You're talking about a legal procedure, but what happens after the operator closes down his business? Where do the niches or the ashes go? By setting the license period coterminous with the land lease, this could solve the problem. How come this is not done? My next question is, why have you set the period as 10 years instead of 15 or 20? Have you answered this question? If it's set at 10 years, say for those expiring in 2038, then at least they would have to be under our review in their renewal application. Some members ask whether 15 years is possible. Well, having heard members' views, we need to do some internal consultation and consider this suggestion. The next question has to do with ashes. Land lease mean coterminous with the license period. If it's coterminous with the land lease, then there is no renewal arrangement to check the operation. It's difficult to revoke the license within, when the license is still valid. And there are concerns from deputations. They feel that they are a nuisance, that the government should ensure that they comply with the licensing conditions. As for ashes, in fact, in Part 7 of the bill and Schedule 5 of the bill, there are clear stipulations. Definitely, the responsibility lies with the operators in disposal of ashes, be it a pre-built columbarium or a columbarium set up after the bill was introduced. Then the operator is responsible for properly disposing of the ashes. Otherwise, the operator may be penalized heavily, as I mentioned. Next, Mr. Tony Chair. Now, having heard your explanation, there is little protection for consumers. The administration explained 2 points, but they're very different from actual experience. Now, just now, the focus was on license period. Now, I don't quite agree. To say that giving a license period of 10 years would make them free from any monitoring or control, I don't agree. I think it gives the impression, and from what I heard, I have this impression, and I think it's unreasonable to say that as long as they are not compliant, then they should be deterred. Now, we talk about the period of license as well as the period of the land lease. I personally think that once the license is issued, the administration can still monitor the licensee and check for compliance. About the template for a contract, this is not part of the regulation. Now, consumers need to spend money on the niche. We talk about a residence for the living and a residence for the dead. But it's questionable whether somebody would really pursue the matter legally. So why can't you give more protection to consumers who pay out of their pocket? And there are loopholes pointed out just now, and I fully agree with these suggestions. 10 years later, these people may have to pay more. And also in paragraph 5 of the paper, there are 7 Columbaria without or not covered by land leases. So what will happen to them? Does it mean that you will grant them a piece of land, and will this encourage operators not having self-owned premises to operate Columbaria? I don't know how you're going to deal with it. Also, I have another question. Well, just now, members expressed concerns over this. Say if the business in future isn't good, and at the point of license renewal, what will happen? Will the administration take over all the ashes interred there? Will the administration take back the land? The operator may wish to cease operation himself. And what happens if the operator then wants to cease operation and then start another business in future? P.S. Thank you, Chairman. Now let me answer Mr. Chair's questions. For those not meeting our requirements or licensing conditions in our bill, we have set out the penalties. Not as heavy as the ones I mentioned, but still they would be penalized. Within the valid period of the license, as for the suggestion of revoking the license when the license is still valid, then there is a question, because the ashes will have to be disposed of, and this also defeats the original purpose. Some members suggest that if you peg the licensing period to the land lease, you may give reassurance to consumers. But if the license may also be revoked in the interim period, then this defeats the original purpose of giving certainty. But nevertheless, having heard members' views, we can bring members' views back for discussion in the government. So once the license is issued, there is no way to revoke the license. That means it will be free of control. No, we do have a review, and we also follow or draw reference from the arrangements for other licenses, and a review may result in an improvement notice. We have this mechanism. In fact, when the license is still valid, if we could revoke the license anytime we want, then this may not be the original intention. And we still have the problem of disposing the ashes. Now, about the 5 mentioned, not covered by the land lease, in fact, at 8 a.m. on the 18th of June 2014, that was the deadline, so a snapshot has already been taken. We are dealing with these cases. That depends on whether they're applying for a license or for exemption. If they're applying for a license, they're required to pay in full to the Lands Department for land lease. That means the land lease will be granted. In fact, in some cases, they can apply for short-term tenancies or other arrangements. Of course, the Lands Department will have to deal with these applications for these applicants for licenses. And like I said, there are also other applications for exemptions. And we'll see how we should deal with that. What about operators not wishing to renew their licenses? In Part 7 and Schedule 5, we provide very clearly that the operator must dispose of the ashes properly. Otherwise, he can face heavy penalties and he'll be imprisoned. But the land will not be taken back. Well, this is just an assumption at this stage. We cannot give you any concrete answer. It's just a hypothetical question. We're just the licensing authority. Will the lands department be involved then? I can't give you a general answer. We must consider the merits of each case. My concern is that the operator, after operating for some time, decides to... Well, please go back to the queue. Next, my turn. I have a short question. I look for a short answer. P.S. You talked about self-owned premises. What is meant by self-owned? What is meant by leases? Self-owned means that the applicant hold the premises directly from the government, that the applicant is the leaseholder. All right, understood. That means originally this approval has already been given for running a columbarium. Yes, the applicant should be the leaseholder or the lessee directly, or that he has the undivided shares registered with the lands registry in a multiple ownership premises.
No, some are not self-owned, but the land is leased now for a number of years, and the land was originally not for columbarium purpose. It's not bought as divided shares, but I signed a lease contract for 8 years, and then I operate a columbarium. But it can be 30 or 50 years. Now it's an arrangement between private owner, and lessee. So it's not on a government lease. Right. So the owner of the lease, now the lease was originally not necessarily for columbarium. Now the leasehold interest was directly acquired from the government. Then he erected a building on the property, and then the levels of the building are sold, and as undivided shares, and so that's still part of the lease. Let's see. Now self-owned, that means he bought the land or he leased from the government lands department. Yes, that would be self-owned. Now, yes, when I'm the owner, then I sign a lease to you for 8 years. Okay? Now, this is a self-owned property, say, and in that case, it may be for 50 years, and then after 50 years, he may have to pay more premium, and the land is used for columbarium purpose, and then he sells niches, and in the contract, it shows that the lease is for 50 years. Only after 50 years would additional premium be paid, and the ownership rights that he sells should have the right to use the niche for 50 years. Is that right? Yes. As specified in the bill, the contract for sale cannot have a validity period of sale for over 50 years. Now, the lease will eventually run out, and then he has to pay a premium, and then the contract should stipulate how the premium is to be shared among all the purchasers. So, okay, so it's 50 years. The purchaser of the niche has a right for 50 years, but the license is only for 10 years. Then there is a perception of a difference. The person who bought the niche owns a right for 50 years. No, the ownership right is different from management. So after 10 years, the manager doesn't do well, so he's disqualified. Now you can change the manager, but you cannot take away the ownership right, because the purchaser initially didn't just purchase the management, he also purchased the feng shui and so on. So if the government doesn't renew the license, then it's more than a question of compensation. The ownership right should be separated from management. I understand members' concerns. Of course, if there's a choice, we would go for the simpler method. But we've heard from the concerns from the groups like the Grand Alliance and the other groups. They want us to be more stringent in our supervision. Now let's not talk about them. Now the ownership right and the management should be aligned. Now, okay, you are saying that if they don't manage well, the license would come to an end, and then would you get back the land? We won't get back. We won't recover the land, but the operator cannot continue to operate. Well, under the bill, that operator has to arrange for the ashes to be relocated. That's a problem, because the contract says that the right is for 50 years or say 30 years. And then after 10 years, you say the manager doesn't manage well, then the purchaser can lose out on a right that's supposed to be for 30 or 50 years. Okay, next, Leung Chi Cheung. I will follow up on your question, Chairman. Now, the license must be linked to the land. Otherwise, what's the purpose of having a license? The license would be just for the government's information. Then it's supposed to regulate, but the public wishes that once the operator runs the columbarium, then the purchasers do not want their ancestors' ashes to be moved. But the government's provisions seem to imply that there would be relocation. Now, say the operator may die, then his child, his son, may not be interested in running a columbarium, so he wants to sell out, and then no one operates the columbarium. Maybe the operator ceases to operate after 8 years. Now, the government says, okay, you can penalize the company, but then the father has died, so whom do you penalize? So when you legislate, I suggest you consider the special situation regarding niches, because people want permanent niches. People don't want it to be just for 8 or 10 years. Otherwise, people will want it to be, everything to be taken over by the government. Then that's a departure from the objective of the legislation. So if you legislate that way, the public will not be confident. Now, once the person has applied for use of the land as columbarium, he must have gained the approvals of many departments. So you should stipulate that the land can no longer be used for any other purpose. So the landowner can say that I will recover the land after 10 years and engage in some business that's more profitable. So that poses a problem. So maybe you should consider stipulating the land to be used, that the land should be used permanently for a columbarium. Now, this may sound unfair, but you must protect the right of the consumer. If you just let the operator stop business and go away and let the consumer lose out, you are responsible. You must ensure that the land is permanently for the use of columbarium. Then otherwise, the consumer gets a niche for only 10 years. Now, the government says you can come and apply for renewal. I'll renew it for 10 more years, and you can renew for 4 or 5 times. But it's not a question of whether you issue the license. It's a question of whether the operator wants to continue to operate. P.S. Now we have heard many comments. Now, due to the operation mode of columbarium, do we need longer validity periods for the license? We will consider that. Now, of course, it cannot be permanent. It can only be longer. I'm saying that your license doesn't have to be forever. Doesn't have to be permanent. Now, when the person applies for license, he must meet town planning board requirements. The land must have been zoned for the right kind of use, i.e., for columbarium use. Now, can the land use be changed? Might it be changed? Well, it's hard to say. Well, there is a term for that land use, right? Now, you can stipulate a term for that land use. Now, of course, it's not decided by your department, but your views should be, our views should be forwarded to town planning department. We are concerned that the operator has made enough money and wants to cease business and do something else. Now, he wants to do something else after making enough money. And then the government is left to tidy up. Now, so why legislate then? It would just be like the current situation in which the government has to take the responsibility. Now, penalty is useless because the purchaser has purchased on the basis of feng shui and everything else. Now, you try to use the mechanism of the license. That's the wrong mechanism. Now, we understand the concern of the consumer, but we also have to heed the concern of the residents nearby. We will try to find a solution. Albert Chen. Now, I hope Ms. Wong can think out of the bureaucratic box. Now, you must think in terms of the needs of the community. You keep thinking, okay, we make an improvement here or there. Now, when all these niches have been sold, people can, the owners can fold up the business for all kinds of reasons. They can be winding up, and many of these niche contracts are only service contracts. The contracts are so simple that you won't believe it, that they are so inadequate. Now, when you issue a license, now you must get a land grant re-grant to stipulate that the land can only be used for columbarium. Now the lands department can do that. Now say abattoir in Chun Wan, that's for abattoir purpose. Of course you can do a re-grant later, but if the agreement is for columbarium, it's difficult to change.
Secondly, now if a license is to be issued, it must be column 1 in the OZP, not column 2, so that the use cannot be changed. If the OZP specifies that the site is for columbarium use, and the land lease it also specifies that the site is for columbarium use, then it's difficult to change. And also, in future, the selling of niches should be linked to the title. That means owner of a lease can get a share of the title. Then you can stop them from playing tricks. So if you want to issue a license, you must stipulate the licensing conditions that the niche is to be linked to the land title. Although the operator may still wind up the business after selling all the niches. Even in the case of property developers, they sold all the flats, and they said that the estate would be served by ferries, and then after selling all the flats, they stopped the ferry services. And there are people coming from different backgrounds operating Columbaria. And I seldom share my thoughts, share the same views as the DAB members. And that means everybody can see the problems, and yet the administration is still acting blind. And over the years, it's not often that we have the same analysis among members. So go back and think about it. You must rectify these historical problems. If you couldn't do good for people alive, then at least do some good for people who have deceased. Well, it's it's not often that Mr. Albert Chan could speak in such a rational manner, but please do speak more softly. P.S. I understand the tricks. I understand that they use service agreements. That's why we're going to have templates in the future for contracts. And in fact, even if it's linked to land title, they can still play tricks. They can still get money from consumers and then wind up the business. They can circumvent all the legislative control. So if they are minded to play tricks, yes, they still can. And having heard members' views, we'll go back and simulate this information. And then we'll go back and discuss and see whether we have another proposal. Well, Chairman, just another comment. In fact, you can consider comparing yourself to the tourism industry for travel agencies going bankrupt or winding up. Maybe in the future it can be something like a fund set up or levy being charged. In the case of Columbaria ceasing operation, you can still have a fund to maintain the columbarium's operation. I can assure you that in the future, definitely, there will be more problems arising from Columbaria than from travel agencies. Yes, we consider that from the experience of imposing levy for tour goers, there are shortcomings as well. Some may never seek compensation, and those are the good operators, and yet they keep paying the levy, and there are some unscrupulous operators making use of this loophole. So we'll go back and rethink and see how we can better address members' concerns. Next, Mr. Gary Chen. Chairman, thank you. I want to reiterate that if the license period is not coterminous with the land lease, there could be many problems as suggested by members. Just now, the PAS responded to my question. She said that a review could be done once every 10 years. That's why the license period should be set at 10 years. And that's what you mean, right? In that case, there could be more gray areas, a wider gray area for operators. PAS just now said that improper disposal of ashes would attract a maximum penalty of $5 million fine and 7 years imprisonment. Now, PAS, I don't know if you know how much each niche costs. We're talking about $1 billion here if a columbarium has 10,000 niches. So definitely some unscrupulous operators would dare to operate in such a manner. And there is no deterrence at all about the 10 penalties you suggested. Now, members across political spectrum have all shared the same view. Please go back and think about it. I'd like to follow up on this point as well. I have a relative. I had a relative, and the ashes, the deceased relative, and then the ashes were placed in a private columbarium, and it clearly stipulates that it runs as a private columbarium only with a 7-year lease. But what about the profit the operator makes? Like Mr. Gary Chan just now said, you could imagine not 100,000 per niche. Basically, you can't get one at this price. For better ones, it costs 300 or even 400,000 per niche. So imagine how much profit they could reap. Now, you talk about penalties, giving a deterrence effect, but no, there's no deterrence at all. If you rely on the operator's management, and if the management is poor, that the lease can be taken back, then definitely this is completely in contrary with the buyer's intent. So the land title purchased should not be undermined. And like other members said, after selling all the niches, there is no motivation for them to operate properly. It's not difficult to sustain good management. It's all about money. If there is enough money accumulated for proper management, then it's not really a big challenge. But if we magnify this issue to the extent that land title would be affected, I think you really have to think carefully. This issue deserves some careful thought, or you may face wide and strong repercussions, especially for those buyers. Definitely the buyers won't accept it. Yes, Mr. Tony Chairman, I want to say the same thing. The whole licensing mechanism or the whole bill offers little protection for consumers. You're creating loopholes. In the future, there will be many disputes. I don't know if all cases would go to court. You better give this more careful thought than to deal with bigger problems a few years down the road. Coming back to the problem of land lease, which is of members' concerns. Have you reviewed to see if changes to land leases are required for the operation of Columbaria? And if so, should land premium be paid? Because this is a special operation. Now, I think the government will be collecting a hefty sum of land premium. To some extent, can the premium collected be used to help consumers apart from templates? And will there be standard contracts to be used, or will it only be used on voluntary basis? Because ultimately, you need to give consumers more protection. Otherwise, you can't resolve the problems. For those making big profits, they have a bigger share of responsibility. The government also receives land premium. So I don't know whether the government will charge a higher premium and give more flexibility to the operators. But I don't think the government is minded to just collect money. The government also wants to manage this issue properly. But the problem is, if it's not linked to the land leases, there are lots of loopholes. No further response? All right, I still have some points to raise. Ms. Chan Yun Han. Well, just now I heard the PAS replies, but I don't think she has given any undertaking to members on how to handle this issue. That is, how consumers' interest can be protected. It was previously discussed. Well, I was also watching you just now. Did you give any undertaking for the validity period of license? Their concern is that the period of 10 years is not pegged to the land lease, and their concern is that Columbaria is the Columbaria are long-term operations, and we should go back and consider how or whether and by how much the license period should be lengthened so as to bring it closer to the the term of land lease. Apart from that, I heard from members that there could be other issues on expiry of the license period, because usually ashes would be interred there for a longer time. Of course, people winding up business, that's another issue. Well, just now members talked about ownership, management, and most of them supported a longer period of time. But longer, how long? On expiry of the land lease, that's according to the prevailing government policy. For example, 3%. We don't know what the percentage is by 2047. Anyway, on expiry of the term of land lease, and if renewal is required, what should be the arrangement on land premium, and what should be or how it should be shared. The consumers must be informed. So PS about land lease. My question is that you should give us answers to our different questions. That means when the land lease expires, what should be done? When the license period expires, what should be done? Now, PS actually just now mentioned some points. It's not just about lengthening the license period and by how much. It also has to do with whether it should be linked to the land leases. Consumers' interest, whether consumers' interest can be protected simply by improving management, or whether other means should be used to ensure that. But it should not be linked to the land leases otherwise. I mean, these are the points raised by members. Now, about the land lease, the term may be 30 years, and you should stipulate that the land lease must not be changed within the 30 years term. That is another issue, and consumers may feel very strongly about it. I just assume that it's 30 years. Let me just answer your first question, and then I'll defer to the planning department. And if we are to issue a license, they need to meet the lands departments and the planning department's arrangement, the requirements. Now, the land use may be changed to Columbaria, but will there be any change in the next 30 years? I'm saying that within the term of the lease, there must not be any change. On its expiry, you can change it. I'll defer to the lands department. Within the valid period, say before 2047, the zoning must not be changed, and I'll let the planning department take that.
Suppose the lease runs out on 2047, then how is it that how can we offer safeguard to the operator and the consumer? Now, the Grand Alliance and other groups, now we will see whether they agree with this proposal to tie the term of the license to the land lease. Now, I'll try to explain. Now, if they have to meet the planning requirement, that is the land use on the OZP. Now, the OZP is under the power of the town planning board. Now, if the person has to apply for a license, now for many private Columbaria right now, they do not meet the requirements under the OZP, and yet they start to operate and they come to the town planning board to apply for rezone the land to columbarium use. They hope that when the license is being considered, they can get approval from the licensing authority. Now, if the land use is changed from the plan, and when the change is shown on the plan, well, let me put it this way. The plan has a statutory power, so when the license is issued, if the planned land use is changed, for instance, now say after 5 years, say after the land is rezoned for columbarium use, now it won't change if there are no particular reasons, but if someone comes to apply to change the land use, then the town planning board will look at the circumstances at the time to see whether there are ground for change. And on the issue of licenses, there might be a requirement that if I issued the license to you for 10 years, the use must be a currently approved use. So the must be a regularly approved use. Now you can stipulate that in the issue of the license. Well, the management might use this tactic so that the use for columbarium is changed. Now, Mr. Albert Chen raised this issue. Now, I agree with him. Now, so they make this change, and then they ask for the plan use to be changed, and so you leave this loophole for this to occur. So you are still talking about the management, and now that this is, in fact, it doesn't resolve our concern. Now, if someone applies for the license, he has to meet the planned land use. Now, if it doesn't meet the planned land use, he has to apply for a change, and there are town planning board procedures. Now, okay, he meets the land use now, so the approval is granted. So the planned land use, will that be unable, is not allowed to be changed in 10 years, over 10 years? Now, actually, the use of the land is under a statutory power. Now, you offer a lease for 10 or 20 or 30 years, but the term must be definite, and that must be tied to the term of the contract. Now, because it's not easy to change the planned land use, you should not let the management exploit this opportunity. Now, it's a complex matter. Now, if the land is rezoned, now there's this issue of changed use. Now, maybe I will supply a document after the meeting. Now, a couple of points. Now, on clause 38 of the bill, if the site is to be used for columbarium, then the operator must register a certificate with the land registration department, so that the purchaser of niches will be informed. Now, on the amount of $5 million of penalty, now you might say that's not a large amount, but the prison term can be up to 7 years. So that's is quite strong deterrence. Now, after the meeting, regarding the arrangements of Town Planning Board and Lands Department, we will provide another document. Chen Yunhan, please give us a written document next time. I don't trust you. Now, I understand what the Lands Department official said just now. Now, after you grant the land, and it's used for columbarium, and then there can be changes in the interim, and the people can play tricks, and they make a lot of money, so they're willing to break the law. So you must provide safeguards to the consumer. Now, I haven't studied the land issues for a long time, but it's still 20 years. Now, it's not easy to change, but it's maybe necessary and feasible. Now, okay, the land is approved to be for columbarium. Then the operator makes money by selling to the consumer. And how do you safeguard the interests of the consumer? And so you must provide an answer for every question. Now, I am concerned about the consumer. That's my concern. Assistant Director of Planning. Now, on the land use, now if you want the land to be used for columbarium, and if doesn't fit the OZP, you have to apply to make a change. And after the Town Planning Board accepts your application, the change procedure will be started, and then there are objections that are heard, and then the EXCO will finally approve it. So now, once the change is made, the new land use will stay in the plan until there is a second application for change of land use, and the change is actually effected. Now, this procedure is established under the Town Planning Procedure, Town Planning Board. I can't assure you that the land use cannot change for 20 or 30 or for whatever number of years. So if the land use is changed, it will stay there until someone applies for a fresh change, and the Town Planning Board examines the grounds, and if it considers the grounds are sufficient, then the change of land use procedure will be started all over again. Now, please answer this. Now, the use is for 30 years. You will not approve a change of land use for 30 years. Now, you have to assure us of that. Now, the question has been asked many times. Now, under Town Planning Board regulations, we cannot provide a guarantee that the land use will not be changed for 30 years. But the purchaser wants to be sure that the ashes can be interred in that particular niche for 30 years. Now, it's the OZP, but the land is already sold to the operator, and there is a term of the lease. Now, how does the term of the lease tie in with the approved license period? The OZP is subject to restrictions under the Town Planning Ordinance. So you must resolve this problem, otherwise there will be a public outcry. Now, if the lease is for 50 years, and if the stipulated land use is for columbarium, then for the Lands Department, we will require the use to be only used for columbarium for the 50 years. Okay, anything else? Actually, it's all very simple. Now, the government says that there is a town planning board, and there is the town planning ordinance. So once the rezoning process is started in respect of a piece of land, then you cannot assure that the use will be changed once again. So you're saying that the town planning board is independent. Now, under the town planning ordinance, once an OZP is established, when somebody applies for a license, then the town planning board well, the approval is already for 30 years. Let me say something. Now, from your perspective, you say that the town planning board has the authority to rezone a piece of land, and if someone doesn't want the land to be used for columbarium, and the town planning board can rezone after it hears the application, and the new use might not be for columbarium. So that is quite possible, right? So the TPB cannot assure people that the land cannot be changed to a different use after a couple of decades. Now, the lease says it can be used for columbarium, but after rezoning, the lease is not effective, so there will be a court case.
Because the land lease requires that the only permitted use is a columbarium, not a school, not a property development. That means that's not in conflict. The land lease only forbids any other use. The land lease belongs to the owner. No assistant. Well, you don't understand, assistant director. Do you understand? If you hold a land lease, you can't do anything else. If the lease says it can only be used for columbarium operation, so you have the land title, you're the holder, and when you proceed with a residential development, you will be stopped because the land lease says only columbarium can be allowed. So there is no conflict. It has to do with policy. You have 7 minutes. You have a lot of time. So the matter is simple. You need to have a system in the law to protect consumers' interests. For example, the columbaria industry may set up a compensation fund. Let's say we have some sort of insolvency fund in the labor sector for something like severance payment. Anyway, what society has is this. If the fault is on the government, then it is not reasonable for consumers to pursue damages because they need to pay for any legal litigation. Now, if the town planning board allows change of zoning or rezoning so that the land can no longer be used for that purpose, then there'll be another legal battle. Well, if in the bill you cannot resolve the problems, it's hard for us to let you pass the bill because nobody protects consumers. For land rezoning, if it's approved by the town planning board, then if it's not allowed by the town planning board, the owner will take this to court because the TPB rezones on its the site on its own, and they have reasonable expectation to conduct business on the piece of land covered by the land lease. The problem is, if in the course of consumers pursuing this through legal means, then consumers suffer. For example, if you put it down, well, the consumers can be guaranteed a niche, so nobody will have any dispute with you. So we have different concerns. but we share the same goal. That is how you can protect consumers' interests in your legislative process. Secondly, how you can protect the interests of residents living nearby. You come up with the whole idea. Some operators operate Columbaria by plugging loopholes when the land stipulates clearly that it's not for Columbaria use. That's why you are tabling this bill, and yet you're not helping consumers, you're not helping residents living nearby, and ultimately you let members suffer because they will be accusing us of being incompetent. We face criticisms as well. So go back and consider the original objective of this bill. I understand that there is a long title in this bill, but if you can't address members' concerns, their anxieties, then we can't let the bill pass. I understand what you mean, that ultimately somebody should be responsible, but does it really help those buyers of niches? No. Then what will happen? Will all the ashes be discarded? And other members like Mr. Albert Chan also made the same point. If they plug loopholes, there's nothing you can do because government departments do not have any coordination. I think both directors of department have made it clear that changes could be made. However, the lands department made it clear that once the land lease is granted to somebody for use for a period of time, then it cannot be changed unless the matter is taken to court. But I understand that you can rely on other pieces of legislation. But that's the situation regarding the land title. Assistant Director of Lands, anything to supplement? According to the land lease, change of use is not allowed. What if the owner applies for change of land use? If there are no problems as far as planning is concerned at that time, then we do have a mechanism. In general, not specifically for Columbaria, but we do have a mechanism for applying for change of conditions of land lease. Mr. Chair. Well, I think members all agree on the same point. There is nothing to safeguard the interest of consumers, or little protection is given under this bill. As mentioned by members just now, for private Columbaria, it's a commercial operation. If there is no profit to be gained, then they will just leave the business. There are loopholes. We often emphasize that for Columbaria, they're not there for just several decades. They'll be there for a long time. After all niches have been sold, what do you expect them to do? To continue to manage the place free of charge? Now, the cases I come across are that they would to perform religious rituals, or during spring or autumn festivals, they would collect money to tidy up the place and operate the columbarium. If nothing can be gained, it's a pure commercial operation. So what will happen? You have to pick up after them. You should consider these principles. Members have already urged you not to be single-minded. You want to improve their operation. We agree. But at the same time, you also need to help individual consumers by giving them better protection. I think little consideration has been given, Chairman, in this regard. 2 points were mentioned, but they're far from sufficient. Now, about the so-called permitted use, it may be the government's policy not to allow any further change for the in light of public interest. There could be resettlement or reprovisioning, like clearance action by the government. But not in the case of private columbarium. This is not what we want. We don't want them to receive payments from consumers and then just cease operation. There are lots of ways for them to do that. So please go back and think about it. Chairman, let me conclude by saying that the government has the same objective as members. We understand that we need to look after the interest of consumers and residents nearby and operators, and that is the objective of this bill. At the outset, we understand that it is the expectation of consumers that the Columbaria should be or niches should be permanent. Now, having heard members' views, we hope that we could come up with a better proposal. Perhaps next time we can discuss with members again. Ms. Chan, you've raised your hand again. Chairman. P.S. You talked about a better proposal, not the best. And this immediately caused my concern. We need to support the administration, of course, and let's say the officials put it very correctly that it's a period of 30 years. But just now, Assistant Director also said that in the interim, if the owner applies for amendment, then owner's interest would also have to be considered. Sometimes we come across building management issues. There are flexibility in these matters. Say for the government to raise the percentage from 10 to 20% before mandatory maintenance is required. That's because many tenants or occupiers do not pay attention to these notices. So if it's 20 or 30 years, you really need to be careful. You need to protect the interests of buyers of these niches. I just gave you a very good example, a live example. So PS, don't give us a better proposal, give us the best, because you can foresee these problems. Some operators are really unscrupulous. The government should outsmart them. Otherwise, you will face a lot of criticisms. Maybe by the time you're no longer a government official, and yet the people would ask who took part in passing the bill. I have a question in your paper. I see that there are 5 Columbaria who are holders of land leases as well as other documents. And there is, I wonder if these are examples of land premiums payable. If so, what will be the consideration? Lands Department? Because I heard about some figures and I was really shocked at them, because hundreds of millions of dollars are involved in the calculation. Land premium, we just use one formula before paying land premium. According to the land lease, the value of the land, and also the value of land after premium paid, and the difference of that is the payable sum. So will you take into account the benefits that could be gained in future comparing to its existing value. So you do make comparisons. I think if the sum is astronomical and beyond anybody's acceptance, and that could be a problem. I don't know the details, but I just heard about some complaints.
Now we can go on to part 2. Just now we talked about land matters, and at the last meeting members were concerned about buildings. Now this is a complex issue, and we deal with that in the bill. So let me spend a little time on explaining the provisions so that members understand the underlying concepts. And at the 2 public hearings, we get the response that people want to resolve this historical issue in a practical manner. Now, if we are not pragmatic, a lot of ashes would have to be relocated, and this would cause disturbance for people's feelings. And yet building safety is important, so we have to meet building safety standards, and we adopt a risk-based approach as we do in other spheres. Now, in the provisions, we have a system that the industry is familiar with. Now, we will work through authorized persons and registered structural engineers or RSEs, and we have this certification system. So what is meant by certification by these AP or RSEs? Now, the licensing board has to be satisfied from assurances given by these AP, RSE that the building is safe, and there may be requirement that the operator has to make some structural changes, and these changes have to be met before the building can be certified. Now, this system, now when they apply for a license or for exemption, we require this certification as a basis. Now, we adopt a comprehensive approach. Of course, if they meet the Section 14 of Cap 124 Buildings Ordinance, then of course they would meet the requirements under Cap 123. But even where Cap 123 does not apply, for instance, Mr. Leung mentioned that, Mr. Leung Chi-Cheong mentioned that, for instance, prior to 1981, the building was already completed. At the time, the Buildings Ordinance was not yet extended to the new territories. Okay, now even if it doesn't apply, then we will deal with it with the certification system. Now, even if Cap 123, we will use this certification arrangement. Now, if they meet Section 14 requirements, now they have to apply under Section 114 of Cap 123 to apply, and if they contravene, we will require that they do what is necessary under the certification system. And thirdly, now if the licensing board exercises its own power under the bill, now if the board stipulates that certain changes have to be made, then the owner have to make the changes, operator has to make the changes. Now we can require that they follow what's required under the certification system. So if it's under Section 14, of course they already meet the requirements. If they don't, then we apply the certification system. Now, what is meant by Okay. When they apply for license or exemption, we tell them that the applicant has to meet the building regulations. What do we mean by that? Now, it means two situations. Firstly, under section 14 of Cap 123, the applicant has gained approval for the building works, and or he has been approved by the building authority, or he has met the requirements set by the licensing board. He has done the certification, then he meets the requirements, and then, as Mr. Leung Chi-Chung mentioned last time, say small houses, new territories, new houses. Now the Cap 123 doesn't apply to them. Now, in those cases, we say that if they are certifiable structures, now. Well, I will explain what is meant by structural certifiable. Now, and if the certification has been done by APRSE for these certifiable structures, then we deem that as having met the building regulations. Now, what are structural certifiable? Now, that means under Section 14 of Cap 123, they have to apply, but however, in that case, Section 123 doesn't apply to them, but they, as Mr. Leung Chi-Chung referred to it, starting first, the buildings, some buildings were built in the new territories before 1st of January 1961, and they haven't been modified over the years, then they would be eligible. Otherwise, we don't allow them. Now, and then the new territories, small houses appeared, and then now under provisions repealed. Now they didn't have to apply to the Lands Department for exemptions. And then 16th of October 1987, then under Cap 123, new territories applicable provisions were introduced, and they have to apply to Lands Department for letters of exemption for these small houses. So these are the certifiable structures. Now, if it's they appear after 16th of October 1987, then they haven't applied to the Lands Department for exemption, then they would be contravening. Now, so if they haven't been regarded as contravening Cap 123 and they apply for license, we have to re-examine how safe is the building, whether the safety is acceptable, and we say if they implement the certification and if they meet the requirements, fulfill the requirements, then we deem them as having met building regulations. Now, when one applies for license or exemption, now whether it's pre-bill, columbarium or not, we hope that they would meet the building regulations referred to just now, but it may be self-owned property, or it may be historical problems, issues that they may not meet the requirements. In that case, we can make a limited adjustments. If they don't meet the regulations, now if the operator now wants the problem is with a structure. If the non-compliant structure is necessary for or ancillary to the operation of the columbarium, Now, and we are talking about bill Columbaria, and they are certifiable structures, and they've met the certification requirements, and only then can they be considered for planning application. Now, let me explain. Now, these are structures necessary or ancillary for the operation of the columbarium. Now, what are certifiable structures? They have to meet several conditions. Firstly, now even if they don't meet the building regulations, yet in the period they already exist right after the bill is passed, and some of the ashes have been interred, and some ancillary facilities are already in place, then we will look at that. Of course, they cannot make new contravening structures thereafter, and they have to meet the following descriptions. It's outdoor and it's ground level, and secondly, it's a single level structure, and thirdly, it's a multi-level structure, but we're talking about the ground level, and fourthly, it appears after 16th of October 1987, but it hasn't gotten the letters of exemption from the Lands Department, so it's contravening, and yet it meets the requirements for certification by APRSE. Then these are for these small buildings. So these are the four categories. Now that includes the case where if the building when it was built, it's on unleased land, chapter 20, cap 28. Now, if they haven't got the land license from the Lands Department, or if they got the land license but they contravene, for instance, they put in an excessive number of niches, now we will require them to get certification. And secondly, it doesn't exclude the case where, say, a building meets Cap 123, Section 14, but now, for instance, in the basement, it has received the buildings authorities approval, meeting Section 14, but now in para 13 we talk about the seeking an exemption. Now it's similar to applying for license, but we hope that they will meet our building-related requirements. But if don't meet those, then it's a historical problem. Now they have to, if they meet the Cap 123 requirements, or if it's a contravening structure, but it's one of the four categories mentioned. Now it's a pre-built certifiable structure, and if it has completed the certification requirement, then we will still accept the application for exemption. Now this may be quite complicated. Now the next part is more simple. We will ask them to submit some plans. The plans must clearly indicate the non-compliant structures. Okay, we will let the PAS finish, and then we will conclude the meeting. We want them to draw a plan. They have to meet the conditions. PAS, Madam Secretary, we will need to further discuss the matter in the future. You have provided a detailed explanation, but I think it's too late to start discussion. Oh, okay, let's. You have already covered the plan issue. I'll be very quick. Now, we mark it on the plan. They cannot make things worse, and it must be for columbarium, and otherwise we will not tolerate these non-compliant structures. The situation will not be allowed to deteriorate, and we will issue guidelines so that the trade and the public and the consumers can have reference to those. So we have to discuss this at the next meeting. The meeting will be attended by the relevant officials. Yes. Yes. Now, I'm glad that the administration has provided very clear information so that we can have an in-depth discussion. Now, this will be very helpful for our scrutiny. Now, due to the time problem, we have to conclude this meeting now. At the next meeting, we will come back to the fourth part of this document, the part on building requirements. So thank you for attending. We wish you a Merry Christmas.